Dear guests, moving forward to our next session, we'll welcome to the stage Professor Athina Sashulidou, who will moderate the first panel on innovation of university teaching in a digital, multilingual, and globalized society. Professor Athina Sashulidou is an assistant professor in criminal law at Nova School of Law in Lisbon, has a PhD in law with a focus on criminal law. Prior to joining Nova School of Law, Athina Sashulidou was a Max Weber Fellow at the European University Institute. During her doctoral studies, she was presented with the DAAD Award for Outstanding Performance of International Students and Doctoral Candidates. Her PhD thesis was published as a monograph by the publishing house Morse Seebeck in April 1919, and presented with the Rupert Karls Award for Outstanding Scholarly Works from all fields in November 2019. Athina Sashulidou currently represents Nova School of Law in the International Consortium of the EU Horizon 2020 Project Trace, which kicked off in July 2021. Thank you.
Thank you very much for the kind introduction. Honorable Alexander Gismundo, Chief Justice of the Supreme Court of Philippines, Honorable Justice Rosemary Declaro Caradang, Chancellor of the Philippine Judicial Academy, dear judges of the Philippine Supreme Court, dear colleagues from the Judicial Academy of Tagaytay, the University of Philippines, the Ateneo de Manila University, the University of Malaga, the University of Deusto, and the University College of Dublin. Ladies and gentlemen, it is my great pleasure to welcome you at Nova School of Law and moderate the first panel of the CALESA conference on innovation of university teaching in a digital, multilingual, and globalized society. This panel comprises 4 presentations to be delivered by 5 excellent speakers who will address new and emerging challenges in higher education settings, making use of inter alia, the COVID-19 experience, and the way the latter reshaped university teaching. I believe that Nova School of Law is the right place to have this discussion, considering that innovation, internationalization, and interdisciplinarity belong to our school's DNA. As a moderator, I have the extremely difficult task of introducing you to our speakers within a limited period of time. I decided to introduce every speaker before the presentation while trying to do justice to their extremely rich scientific and professional profiles. So without further ado, I would like to invite Professor Carlo Vistan, who obtained his Bachelor of Science degree first in molecular biology and biotechnology, and then a Bachelor of Laws degree at the University of the Philippines. While in law school, he worked as a court legal researcher and later on as acting branch clerk of court for branch 227 of the regional trial court in Quezon City. He has collaborated with several law firms, and now he has his own practice and handles mostly litigation and election cases. He also teaches at the Angeles University Foundation School of Law. Professor Carlo Vistan, it's a pleasure to have you with us, and we are looking forward to hearing your presentation on the challenges, adjustments in clinical legal education, the UP law experience.
Thank you very much, Athina, for that kind introduction. And since we were given, I think, 10 to 12 minutes to present this, allow me to skip the usual pleasantries, but allow me to say that I consider this an honor, privilege to be speaking before members of the judiciary, past and present of the Philippines, colleagues from the various participating institutions of CALESA. And I chose this topic not only because it's close to my heart. Before I became dean, I have been handling the clinical legal education component of our curriculum, and because it touches on several of the themes of both CALESA and this conference. So there's a a lot of capacity building talk or concerns here, a lot of innovation, digitalization, touching also on multilingualism and globalization. So my topic is on the challenges and adjustments in clinical legal education, the UP law experience. Actually, our Chief Justice mentioned this in his keynote speech. The innovation really is that prior to 2019, there was no compulsion on law schools to offer a clinical legal education or practicum component in their curriculum. It was optional. But starting, I think this year, starting next year, for admission, for you to be allowed to take the bar examinations, for you to be allowed to enter the profession, you must have taken during your law school years clinical legal education courses. So that is a big innovation in the legal education system of the Philippines, introduced by the Chief Justice before he was appointed. He spearheaded the revision of the rules of court on this matter. Okay, let me just check. Okay, so just so we're on the same page, what does clinical legal education mean in the Philippine setting? The Supreme Court, by the rule that was passed in 2019, defined a clinical legal education program as an experiential, interactive, and reflective credit-earning teaching course with the objectives of providing law students with practical knowledge, skills, and values necessary for the application of the law, the delivery of legal services, and promotion of social justice and public interest, especially to the marginalized, while inculcating in the students the values of ethical lawyering and public service. So under our system in the Philippines, it is undertaken in either a law clinic or an externship. And it incorporates the teaching of legal theory and doctrines, practical skills, as well as legal ethics. So the related terms would be apprenticeship, maybe in other jurisdictions, and a law practicum course. So in the University of the Philippines, we have been doing this a few years after we were established. The college was established in 1911, and in the college's catalogs of the period 1913 to 1919, they describe separate mandatory courses called practice court and trial practice, wherein senior students were expected to gain actual experience in preparing pleadings, brief making, and trial work. In the trial practice course in particular, students were to assist in cases, real cases, even as students, by working in a legal clinic that is open throughout the year. So this was early on in the life of our college. Around that time, now this I haven't been able to verify, I'm looking for the rule, but in an essay by one of our former deans and former Justice of the Supreme Court, Irene Cortez, she refers to a Supreme Court rule around 1918 that provides that a student had the choice of spending senior year in law school or as an apprentice in a law office. So the idea is not really new. Even if I said earlier, there was a recent innovation in 2019 of requiring this in all law schools. In 1974, our college established the UP Office of Legal Aid, or OLA. Hello, I think in Spanish, right? So, and the formal inclusion in the curriculum of practicum courses to be completed during the senior year through internship at the UP OLA, as we call it. So summarizing the features, picking out the key features. So clinical legal education in the UP context is combined with providing free legal aid services to indigents and underrepresented clients, or those who cannot afford to pay lawyers to handle their cases. The OLA, Office of Legal Aid, newer law clinics at UP currently assist hundreds of walk-ins and new referrals a month at offices that hold regular hours Mondays to Fridays. So Ola, hello. We're open. No? Ola is open. Anyone can come in. They can consult us. They can request us to handle their cases. We do have criteria as to what cases we will choose to represent, because it also has resource implications, as I will explain earlier. But what I want to emphasize here is where we're coming from vis-a-vis the new innovations introduced by the Supreme Court. And just to share also that because we've been doing this since 1974, close to 50 years, we're almost 50 years running, the nature of the services and the public nature of our university gives rise to community expectations. My example here, I hope you can see it, but so judges in courts refer cases before them, those who do not have lawyers, to our office. So we have the scenario here is one of our students is appearing before the court, representing a client supervised by a member of the bar, by a lawyer. Then after their case is done, if the judge sees that one of the parties in the cases that was called that day does not have a lawyer, they will ask our lawyer, so maybe you can consider representing this particular party who we haven't met before. So I'm saying here is that, what I'm saying here is that maybe as we go forward with the recent innovation of requiring all law schools to do this clinical legal education in their curriculum, there will be similar expectations from law schools. And I think that's a good thing, because the reason why we have an opening to do this is there are many litigants, many parties in the Philippine judicial system who really can't afford lawyers to defend them in criminal cases or to pursue civil claims. Okay, so with that history and with the recent requirement that all law schools have this clinical legal education component, our university has been asked several times what should be done, what are the best practices, and what I'll be sharing in the few slides following are what we share with them. So as an overview, the key points that we share to the other law schools is that the legal clinic, the CLE, Clinical Legal Education Program, must be able to provide learning opportunities of adequate quantity and good quality. And then some of the things that I will be touching on is that what we experienced during the pandemic and how we are dealing with moving away from the pandemic. So the first challenge really is, how do you provide coaching, mentoring, or supervision to several students? As I will show later, for us, it's about 200 students in one term. Okay, you have to be able to provide adequate, but by that I mean sufficient instances, not only once, twice, but preferably more. As they say, practice. You have to practice 10,000 times to master something. And so, but of course, we cannot even approximate that. But the key here is to provide enough opportunities. Another challenge would be to diversify the learning experience, have our interns experience different kinds of cases. And then also we have to cope during the pandemic with remote communication. So because offices were closed, they still had to do their practicum requirement. So how did that happen? So while our students were not in campus, those who needed legal assistance still went to the offices. And we had a video conference set up so that they can communicate with our students while our students were at home. But that was a challenge. It's still different. It's still a different experience. We still believe that it's a more effective way to serve someone for their legal needs if you're talking to them face to face. Administratively, okay, the concerns or the challenges would be to enlist or recruit an adequate number of supervising lawyers that can, in our situation, mentor around 200 student interns during a term. A supervising lawyer is like the professor in this relationship, and it's actually required in the Supreme Court rule that a student can do law student practice or this practicum, appear in court, sign pleadings only with a lawyer, a member of the bar, going with him or signing the document with him. Another challenge would be administratively, handling pandemic-induced digitalization. So because we had to go digital, we did not have the guidelines, the safeguards in place at the beginning. So we had to develop this. And as we go forward with, I think the digital way of lawyering is here to stay. We have to improve on that and inculcate that also in our teaching of practical law practice. Sorry. And then we also realized that when we became digitalized, we became more accessible to Filipinos abroad. And we do. I'm sure you know, or maybe if not, we have a significant number of overseas Filipino workers, people who have to migrate to different countries to find jobs, and they are the ones sometimes who communicate to us to consult on legal problems as to their status, as to their families, as to their property here in the Philippines. Okay, so what adjustments are we trying to do? So mentoring, coaching is best done if the student-teacher ratio is small. So we're trying to achieve a ratio of 1:8, and that means recruiting for a 200 cohort. That's about 25, maybe around 25 supervising lawyers. That's more than double of the number of supervising lawyers we had when I took over. Then we also want to increase opportunities for collaboration and sharing of experiences among the students to help them learn better. So this is based on the self-directed learning principle. You want your students to be explaining what they're learning, what their problems are, so you know that they're grasping the lessons, the practical issues in the right way. And of course, we want to continue to build on the gains in digitalization that we mentioned earlier. So to cover the concern earlier about expanding and diversifying the learning experience. So in 1974, we only had the OLA. Right now, we have other legal clinics mentored or supervised by different professors or members of the faculty. We have these other clinics. I won't enumerate them anymore to save on time. Then we have also partnered with other institutions. These are what we call externships. They do their law practicum in other institutions, of course, supervised or monitored by members of our faculty. So we have arrangements with the Office of the Solicitor General, the Philippine Competition Commission, the Commission on Human Rights, and recently, the most recent one is the Human Settlements Adjudication Commission. This is the agency that deals with housing problems or cases. So this is really one of the major issues or concerns, not only of our college, but of all universities, engaging supervising lawyers. Whatever we do, I think whatever any institution would do, we cannot match what private practice pays these practicing lawyers. And we do want practicing lawyers to be the supervising lawyers so that they can transfer their knowledge and practical know-how to our students. So if we cannot pay them enough, how do we make it attractive? So we give them much autonomy and authority. We have devolved many of the decision making points to the supervising lawyers. And of course, I think many of them don't really do this for the money. They do it for fulfillment, the desire to teach. And I try to compensate that by giving them a free hand. Before the director has myself, I have to decide on which cases to accept. I have given that decision to the supervising lawyers, number one, for efficiency, and so that they also will feel that their contributions are valued. So one way to recruit more supervising lawyers is to recruit from graduates. And to do that, we are trying to make their internship worth their while, a good experience, so that they would pay it back. And we also try to update them with the case outcomes. Of course, they handle the cases while they're students. Normally, they won't see it decided or end. So what we try to do is we try to reach out when decisions are handed down, not only to update them, but also to somehow build a bridge. Maybe you can help us out here when you have time. And there's a lot of turnover in our supervising lawyers because they're really practitioners trying to integrate teaching somehow in their lives. They're not really keen on being full-time faculty members. So a lot of them rest for a while or quit to move on to other things. So this is a constant capacity issue with the clinical legal education programs in the Philippines. So I'm about to end. So these are the key points that I tackled. The clinical legal education experience, we want to have it, we want to handle it in a way that improves on the approaches of mentoring, coaching, and self-directed learning. We also want to build on the diversity of our students' learning experiences. And we recognize the crucial role of the supervising lawyer and the importance of having enough of them. So that would be the end of my presentation. As we say, thank you. Maraming salamat in Filipino. I'll be glad to discuss this later on with all of you. Thank you.
Thank you very much, Professor Carlo Vistrana. I'm sure that we are going to have a very energetic debate afterwards about digitalization and accessibility, knowledge, and practical experience transfer. This was extremely interesting. So the second presentation will discuss post-COVID legal education with Dr. Richard Collins and Dr. Marie-Louise Paris, sharing with us their preliminary findings of technological challenges and opportunities at UCD Sutherland School of Law. And let me properly introduce you to the next speakers. So to begin with, Dr. Richard Collins joined UCD Sutherland School of Law as a lecturer in law in January 2015 and was promoted to associate professor in October 2019. He was previously a lecturer at the School of Law of the University of Sheffield, where he also obtained his PhD diploma. From 2016 to 2020, Dr. Collins was also Vice Principal for Internationalization in the College of Social Sciences and Law. He has held various visiting research positions at the University of Copenhagen, the University of Sydney, the University of Helsinki, to name just a few. And currently, he's also the UCD academic coordinator for the CALESA project. Our second presenter will be Dr. Marie-Louise Paris, who is also an associate professor in law at the UCD Sutherland School of Law. Her primary research interests are in European public law, European human rights law, and comparative constitutional law. And her latest research project has been in the area of deliberative democracy and citizens' assemblies, and on the topic of the civil-military relationship, where she has published extensively. Marie-Louise has also an interest in legal education and legal methods, and I guess this is what she will be sharing with us today. She is currently the academic director of the UCD Center for Human Rights, and of course, before all this, she received her legal education at the University of Paris de Panthéon-Assas in France. Welcome on board, and we're looking forward to your presentation.
Your Excellency, Chief Justice, and distinguished guests, thank you very much for your attention today. On behalf of UCD, I'm delighted to be here at last and to meet you all in person. Thank you to colleagues from NOVA for the warm welcome. It took me a long time to get here, with a saga journey to get here, but it was an extremely warm welcome to start. So thank you. Marie-Louise and myself are going to be talking about our experiences at UCD. We've got quite a lot to get through, so I'm going to try and move through it quite rapidly to stick to time. I'll put my timer on to make sure that I do. This is a bit of a departure for me. Usually I talk about the sea, fish, pirates, that sort of thing. So this will be an interesting departure to talk about our experiences. And this is like a collective therapy to go through the trauma of the last 2 years to see what we've learned from it and how we're going to move forward afterwards. So hopefully technology will start my timer. So the pandemic was widely acknowledged as a sort of existential impact, of course, on the health, social welfare, mental health, but also education. The OECD has acknowledged the unprecedented educational impact on our youth, our children, but also at the tertiary level, at higher education. What we want to talk about in this presentation, though, is whether we can also see this as an opportunity as much as a threat. Legal education, as we've already begun to discuss, was undergoing pressure for change in many jurisdictions around the world through internationalization, through new technologies, through the shift in kind of the traditional demographic, shall we say, of the traditional law student, which has pushed already a drive towards more open learning, online engagement, and greater learning flexibility. So these are some of the things that we're going to talk about. But it all happened in rather a hurry in 2020. It was a rapid shift online. What have we learned from that process? So I'm going to first talk about this idea of the pandemic as a disruptor versus the idea of the pandemic as a catalyst for change. And we'll look at some research on online teaching provision, asynchronous versus synchronous, live versus recorded kind of provision, to see kind of the threats and benefits and the potential for moving forward. I'm then going to switch seats. Well, I'm going to move, and my colleague Mary-Lise will come and talk about our own. We've done a little mini study in UCD of our collective experiences in preparation for this study, and we'll talk about that and look forward to future challenges. And I'll come back at the end to talk about that. So a colleague in our school, Professor Justin Hutt, published a paper where he referred to the rapid move online, not as a shift to online learning, but as an emergent, what was it, ERT, emergency remote teaching, which is a very good summary of what happened in 2020. It wasn't a planned pedagogical move to shift to online. It was, we've lost our audience, what are we going to do? And that's what happened. There was new technologies needed, a change in assessment methods needed from traditional exams to online assessment methods, and not very much time to think about how that was going to work. So the pandemic has been a very rapid, very brutal, very steep learning curve as an experience for us, but it's left some residual concerns. And certainly if we're going to retain some of the technological advances and shift to online, it's left some residual concerns about that experience. One concern that the move online potentially undermines the in-person experiential clinical aspects of legal education. And you can see in this picture on the slide, this is actually UCD's, a few years ago, we paid for a brand new building with a clinical legal education suite. And that's the moot court you can see on the picture in UCD. Are we going to throw these things out the window if we're going to shift online? Are we learn these? We're going to lose these experiential learning parts where we'd invested heavily. Okay, we've lost the ability to move forward or backwards on this slide. One drawback of the shift to technological online learning is when technology doesn't work. It's happened to us on more than one occasion. My students see me as the killer of technology whenever I go in front of them. Even just in-person learning, something always goes wrong with the PowerPoint, the presentation. So here we go, it's back. Hey, okay. One other concern, if we're moving online, is the risk of potential cheating or academic misconduct, potential copyright infringements if learning material is posted online, but also whether the enhanced technology requirements of providing online learning actually results in socioeconomic inequalities. Not everybody has the access to the same levels of technology. But on the other side, there was already before the pandemic pressure to move in more of a technologically advanced solution. The need to re-envision the future of legal education existed well before the current pandemic, spurred by the shifting nature of legal practice as well as demographic technical change. Can we see the move online as a benefit as well as a catalyst for change? Well, even before the pandemic, existing research in legal education was beginning to look at the experiences of online learning provision, particularly lecture recording. Simple, even if you're having the in-person experience, what happens when you provide more learning material online? And one of the concerns has been possible disengagement through asynchronous online provision. Pre-pandemic studies show significant drops in attendance when materials are provided, so you lose out on the in-person experience. And a 2020 study just before the pandemic started, in fact, in Australia found a similar trend, though the authors of that study caution against a sort of simplistic view that providing recordings of lectures necessarily results in disengagement. It depends on the context of how they're used and what they're used for. Many students found benefits from having the additional resources provided to them. But real concerns, sense of the remoteness creates a potential disconnect between learner and teacher. There was in their 2020 study a demonstrable evidence of drop-off in student performance as a result. But potential positive elements from existing research show that if used well, online teaching interfaces can work well. They can actually enhance student-teacher interface. The idea that you're always online, or at least perceived to be always online and able to answer and respond to discussion boards and so forth. It potentially also broadens rather than causes inequalities. You could, through having a wider engagement, broaden the demographics and reduce the costs of legal education. The other thing, and this kind of ties into the previous presentation as well in terms of clinical legal education, that the use of IT to respond to real world changes in kind of virtual courtrooms, this idea of virtual law cases in the US, there's been some research on the potential benefits of online clinical education to recreate kind of compelling legal scenarios. So just to reiterate this point that I had in the introduction, the need to re-envisage the future of legal education existed well before the current pandemic. But, and this is some final points before I switch to our study and my colleague, what the research does show is that if you're going to do this, you've got to do it properly. You can't just record and stick things online and try and recreate online the same kind of experience that you would deliver in person. Careful preparation, the employment of educational technologists, people who are skilled in providing content, staff able to be online and to respond to queries, to create that perception of engagement between learner and learning. But this can potentially lead to pedagogical innovations, the move away from just broadcasting, recording of traditional lectures and online seminars towards more of a potential Socratic online method, use of discussion boards where you can leave a comment, respond to it, encourage self-learning research and move forward. Rather than putting full lecture recordings up and just simply blasting information there, using short engaged lecture videos, engaging discussions, creating active learning, and pushing the debate forward in this sort of more creative way. So on that point, I'm going to hand over to my colleague to talk about how we then asked questions around these threats and benefits at UCD.
Okay.
So thank you very much, Richard, and thank you for the organizers for a very interesting event so far. It's a real honor to be invited to talk before such a distinguished audience, Chief Justice, members of the judiciary, and dear colleagues of the Nova School of Law, and dear colleagues from the partner university. So I'll talk a bit about our survey, which is a very small survey. You know, Ireland is a very small country. It's a small island. And we actually did a survey over the summer just to test or to know about the experience of our colleagues about these shifts, these very traumatic shifts for some people to online teaching. So you have the figures on the screen. So as you see, the numbers are very small. We are a small school of law, but very dynamic and very active. So 38 members of staff were asked to reply to a few questions as a survey. And it's kind of split in terms of gender equality. It was good. In terms of response rate, it was quite good. We were quite happy. And obviously all the response were anonymized, but I would like to talk about first the questions very quickly. And then I will do a bit of analysis before talking of a kind of innovation. And I've talked at the coffee break to some of you about these micro-credentials innovation that we are experiencing. And that would be my main point for my part, because I know the time is counted. So in terms of questions, we had 6 questions, very simple ones. What do you like about teaching online? What do you not like? Do you plan to do more teaching online after this has all stopped, the pandemic? And then we had a set of 2 other questions. One was about the resources, because we wanted to know, it's very important actually, the resources for the university itself. If the university has to buy, for example, a license for Zoom, which UCD did, for example. And then the micro-credential question. So I don't know if you're familiar with that. We can have a discussion about that. So I will explain what it is, but that was one of our questions, because we are actually with Richard turning each one of us a module into a macro-credential module. So that's it's linked to online teaching as well. So in terms of analysis of the answers, or the replies, it's funny because the responses were really of the first question about how do you find this online teaching shift. The responses were quite polarized. Some people were very positive and some people were really negative. And in the negative responses, they were very short. They didn't expand, or they didn't explain why they didn't like it. Whereas other people who were more positive were quite, very, they were, more maybe positive looking and explaining why, they adapted so well. Although the problem with that, there was the problem of technology, precisely, and the problem as well that you had to adapt to a new technology, which was not easy for some staff, because it depends on the support you have. And in some universities, for example, you don't have as much support IT. But then the main negative point among even the positive answers were that the student engagement was good at the start, because it was all new and exciting. And then there was a drop. And what we experienced in UCD, for example, even this year or the last trimester of last year, the level of engagement, even if we went back to the physical teaching, was not good. It was really a big. So we are just starting teaching last week. So we are trying to see if the following weeks will be better in terms of students' engagement. But the most negative point, I don't know if it's the same for your schools, student engagement is not the same. We have to build it back, so that's, yeah. So in terms of flexibility, I suppose, in terms of positive points and what you like, I suppose it's the same points as you have experienced. And especially, for example, for different kinds of learning, students who are more shy, they can ask questions on a chat, etc. So that was a good point for teaching online. A point which is very specific maybe to Dublin. Dublin is a very expensive city. If you have to live in the city, and it's expensive for students. So the fact that they could stay in there outside of Dublin, not to commute, that was good. Even for staff, if staff were living a bit further, or you don't actually have the stress of commuting. But that's aside from obviously the teaching part. And you could also innovate in terms of online teaching using discussion boards and all that. But that's a quote from, you see that the responses could be very elaborate. So that's a quote about this change. It's a bit cynical. So a lazy and deeply cynical academic could find many things to celebrate about online teaching. You can sleep in later. You can record lectures in advance rather than to go to bother of giving them live. Recorded lectures can be recycled again and again. The greater distance between the teacher and students means that there is much less chance of awkward questions and being put on the spot. Less student engagement means less work overall. Those who hope that this will be the future of education need to take a good hard look at themselves. So if, as Carlos said, if you have to combine these for the future, you have to do it well. We can't actually afford to have, to start with a really bad online ethics, online education ethics. So because people are very, so the negative aspects, the most, the important ones were, I mentioned already, the low level of engagement. And between staff as well, between colleagues. Obviously, we didn't have these coffee mornings and all that. And the difficulty to gauge the students' experience if they were learning properly. And also, initially, the increased workload for us. And some staff are more willing than others. Some staff are better with technology than others. I'm on the lower end myself, not very good at technology. So maybe that's gone because we are all okay now with technology, but you never know. About this, the fact we asked the question, do you plan to integrate online teaching in the future? Although we have passed the pandemic, so there were three perspectives, if you want. One was that they were already doing it. They were already delivering online teaching, so they were continuing that, or preparing for new modules online. The other people, like I do myself, I still do flexible hybrid formats. So I have Zoom and the class in the room, so I have a hybrid format. And then the micro-credential model, which I will talk about a bit, it's a new way of approaching the design of your module. So I leave that aside. It's about the resources. It's not so major, but I would like to talk about these micro-creds. So micro-credentials, a majority of our colleagues actually knew about that. Which surprised me. I didn't think they will be familiar with that. And some, most of them had a very positive outlook on this way of approaching teaching. And I will give you in the form, in the following slide, this is actually what is a kind of definition of these micro-credentials. So before, I don't read the quote in extenso, but just to give you an idea, it's the fact that a module is designed to be chunked, to have segments of learning skills. And this module can be stacked with other modules. It is taken as a standalone module, and you can put it together with other modules towards a master or some degree that you want to do later on. So it's for a diverse audience, for professionals, for people returning to education, etc. And it has to be very orientated. So this is a very flexible way. So basically what it does in practice is that you completely redesign your module on the interface, on the online interface, and you have chunks of activities that you have to do. For example, a quiz, for example, a video that you can have a look at. You are very, and you have to have outcomes, and you have to fulfill these outcomes. So the lecturer really feeds the students with very specific targeted knowledge to acquire. So we are more or less doing that already, but it's more formalized. Okay, so that's the new thing that I think myself, I personally think that it's future of legal education. So in terms of the last question, this was about, do you think micro-credentials will actually is actually good? So yes, it facilitates multidisciplinary learning because you can choose modules in different schools, in different disciplines. But it has to be done in the right context, in the right with the right methodology. And some people were also very cynical because they thought that it was only for the university to gain students, because and then so we are happy to discuss and to take your experience if you know about micro-credentials about that. So and I leave Richard to conclude. Thanks very much.
Hello, I'll be very brief because I'm aware we're well over our allotted time with the slight interruption in the technology. Basically, this topic remains divisive, and we see that in the literature, but we also see that in the responses that we received. The most negative responses, as you saw, were quite blunt and unequivocal about the potential impacts on what they view as traditional legal education. But as we introduced at the start, more constructive responses did see some benefits and some cautions, and this allows a way forward in terms of thinking about a potential integration of technological elements, thinking about pedagogical innovations in improving our teaching moving forward. So just to try and reflect on micro-credentials, this is not a sales pitch for micro-credentials. Both Mary Luce and I are both doing modules that were traditional postgraduate modules that have been moved to the micro-credentials format. It's a way of opening up those modules to a broader audience, but it is more outcome focused. This makes it more, in a way, almost more kind of tertiary on, what's the word I'm looking for, where you have a experiential based learning, but in a very specific way. But it does provide for more flexibility, and it does open up, has that kind of democratizing push behind it. It can be, as we've both experienced, it can be blended to existing program delivery, but these are the potential limitations. Is it too outcome driven? Does it suit some topics that fit that model more than others? And as we both experienced, it's been very, very time consuming to actually put one together. So with that, I'm going to finish, and thanks for bearing with us through some of the tricky points of technological failure to highlight the experience. But we're happy to take any further questions for anything that we've rapidly advanced through. Thank you.
Thank you, Richard and Marie-Luce. You actually managed to stress in a very successful way different elements of online teaching. I have just summarized them as the risk of disconnection between the learner and the teacher, and at the same time, the potential inherent in new technologies as to strengthening that relationship, the challenge of engaging students when we are back in the in-person classes. I totally share that sorrow. Online education ethics, a very good point. Facilitation of interdisciplinary learning in online settings, among others. I will be more than interested to talk with you about the institutional approach to online teaching in Ireland in the post-COVID-19 era, and whether do you plan to invest more in online teaching. This is something that we are also discussing at the level of Nova School of Law, and I think we can share our experiences. And without further ado, let us move on with the third presenter, who is Marianne Alef. Marianne Alef is an associate professor at the University of Deusto. She holds a PhD in economics and business sciences. We do have a truly multidisciplinary panel for you today. She was courageous enough to start teaching at the Faculty of Law, so to non-specialists, where she teaches Introduction to Economics in the degree in Law and Strategic Management in the major of Economics. She has been a member of the Identity and Mission Committee at the university, and she is currently part of the university's Teaching Innovation Unit. At the Faculty of Law, she has also been Vice Dean of Students and Identity and Mission, and responsible for quality assurance. Her research focus lies on business and innovation in education. So, thank you. The floor is yours.
So good morning. Thank you very much for your presence and interest. But before all, I would like to thank Professor José Manuel Torres for the opportunity to be here, and especially Felipe Gomez, a dear colleague of our University of Deusto, for the trust he has always placed in me. Well, at this meeting, we are participating in a project of faculties of law, and in the current context, we face great challenges. Our previous colleagues, I think you are a very good background for my presentation, so thank you. This short paper will perhaps be somewhat different from the rest. My intention is to share with you what might be considered essential when responding to these challenges from a specific approach, the perspective of St. Ignatius of Loyola, who was the founder of the Society of Jesus. I am aware that some of us here today are people who do not come from Jesuit universities and others who do. And I hope to offer something enriching for both. Well, to do this, I am going to present two preliminary reflections. Then I will point out the different challenges that universities face from an Ignatian point of view and how to address them through the different roles we play as university teachers. Finally, I will talk about some hindrances and also I will mention some aspects that could help. Well, here is the first reflection, the importance of the good received, the gratitude that leads to action. Adolfo Nicolas, the former general of the Jesuits, mentioned in one speech that there was a very touching television program in Japan, which was about finding out in a celebrity that person who had most influenced his or her life. Then they would bring them on the television and the emotional encounter would take place. Well, it turned out that most of those who had most influenced the lives of these celebrities had been their teachers. So teaching impacts on others. Moreover, the gratitude for the good things we have received encourages us to give them back to others. That is why it is worth reflecting a little about this fact. And now the second one, the what for, the purpose of the university project. We are referring to the legacy that Ignatius de Loyola left in his educational institutions. I think that there are 200 universities around the world, Jesuit universities around the world. The first Jesuits, nearly 5 centuries ago, soon realized that education was a very important way of helping others. Where there are different statements and different documents on this purpose, but to be brief, I have chosen one of precisely Adolfo Nicolas, the former Father General. And he said, it is not about training the best in the world, but training the best for the world. So the excellence of a professional is measured first and foremost by the parameter of the greatest service to the human family. Well, I am also sharing with you something I particularly like. Yeah, that is the symbol that he used with regard to education. And he told us it is to train giraffes. Here you have a giraffe. Because the giraffe is the animal that has the highest vision and the biggest heart, as it needs to pump blood up to the giraffe's far head. Well, now we turn our attention to our students, who are the other players in this story. We would have to encourage them, like giraffes, to raise their heads and their sides, to strengthen their hearts and identify some of these words challenges I am going to present, all in relation with social justice. Exclusion, hunger, extreme poverty, despite general progress in better living conditions, inequality, drastic changes in the nature of work, our planet, our common home, which is dying. Well, if we started with what we surely do not want from our students, we could refer to a thought from another Jesuit, Luis Ugalde, Basque one, who at the graduation celebration told the students, we do not want successful professionals in failed societies. So what do we want? Well, we want future professionals who face those existential limits that we call frontiers, who discover other truths and allow themselves to be transformed by them. We want them to be able to identify in these realities ingredients of novelty that they can use in order to advance towards a horizon of greater justice where human dignity prevails over any other criteria. You will agree with me that this is a great challenge. Well, now I will focus on the roles of the teacher on this Ignatian perspective. You will see that it is not so much a question of specific roles or even a class, but of the orientation we give them. In teaching, we play many roles. We are organizers, facilitators, motivators, evaluators, coordinators, and of course, leaders. A mere trifle. But let's take a moment to see how Forges, a great Spanish illustrator who died recently, expressed it. I will translate this cartoon for you. There's a civil servant that asks a lady who, judging by her hair, looks a bit stressed. Your profession, please. And she answers, entertainer, educator, actress, mother, psychologist, jurist guide, accompanist, translator, speaker, linguist, psychiatrist, designer, trainer, writer, drawer, gesticulator, and worker. Where the civil servant says to her, I can't fill in all that. And then she replies, then write teacher, which is the very same thing. Well, if you have first identified a little bit with her, that means that we are on the right track. Because jokes apart, this means that we have a commitment that leads us to adapt ourselves to any need. Well, let's have now a look at our roles in the university classroom. And here we have the first one, the role called motivator. In an educational institution, it means that we have to move students toward learning. But from an Ignatian point of view, we wanted to go further, to move towards involvement and action in order to change evil for good. Well, and our presentation of Carlo comes here very, very well. This is how our teaching can impact our students if we provide them with the theories, but also bring them closer to the real world, to guide them and look at it in a certain way, looking at people, looking at the relationships, at the consequences of decisions, at those who are harmed, to feel from below, open their minds, but also their hearts. In this way, they will see the transcendence of their study, the sense of their effort, and they will be able to feel the desire to act. Ignatian pedagogy seeks this constant interrelation between experience, reflection, and action. What underlies all this is the incorporation of the affective component into the cycle, that ingredient of feeling which experience in combination with reflection provides, and thus leads to motivation, to the desire to act. Now we turn to the coordinator role. And we come back what to do in the university classroom. And here I am referring to the Mary Lou's presentation, because there is a trade-off in everything. If we spend most of our time in the classroom on presentations at our own chart, we take away time for debate, for dealing with real problems that arise, for students to express and listen other opinions to form their critical sense. The role of the organizer. Here we are talking about planning. Planning is an unavoidable exercise of reflection on the part of the Ignatian teacher, who takes into account what the students are like when they arrive at the subject, what he or she, the teacher, wants them to be like at the end, and what the most appropriate way to achieve this might be. Not less important, the role of evaluator, which is. Well, at the meeting of the Spanish State University Teaching Network a little over a year ago, I had the opportunity to discuss the importance of the development of the self-regulation on the part of the students, which is most important in the online learning, a real sign of academic and intellectual maturity. I corroborated what I already suspected, that whether students make progress or not in their self-regulation, it is not facilitated by letting them do, but rather that feedback is a fundamental component for promoting their development, guiding them, redirecting them, and opening the way for them to go further. Next one, the role of the facilitator. If I had to choose an image to summarize this role, this could be it. The painter is looking at an egg and is painting the bird it could be. It is about seeing the potential of our students and facilitating their development. It is about looking at reality through the eyes of all that it has to offer, a bit like the Pygmalion effect. And finally, the role of the leader. As an Ignatian leader, leadership is associated with service. And here I bring you a reference image with regard to service. Jesus washing the feet of his disciples at the Last Supper. Here we find the image of a wise man who puts himself at the service of others. This image tells us a lot. He, who is the master, the one who holds wisdom, in his farewell wants to transmit humility and service. What is the message he is sending to us, teacher? He is telling us that being a teacher is incompatible with arrogance and with a subversive attitude. Now we will talk a little bit about what can discourage us and what could help us. And let's have a look. Let's look at some of the hindrances. Well, the journal Nature warns us about this issue. This last February, it published an article with this headline and photo, alerting university institutions to redirect their motivation system towards teaching. It is clear that the university has become considerably more complex over time, so much that sometimes, instead of facing teaching with passion, it can become a burden. The overload of tasks can lead us to put our teaching on a secondary level, and there are many factors that work at it. For example, we work with students who are becoming more and more different from the way we were. Research is a must, but not only research and publishing. It is also necessary to do it in certain journals and recognized spaces. The quality agencies have become very demanding, and we often respond to the impulse of the bureaucracy and not to the substance of the question that could interest us. Not to mention the management tasks, so necessary, but often so thankless and unrecognized. Moreover, in universities, all this is accompanied by novelties every year, new subjects, new research projects, new management tasks, new, and the novelty excites, motivates, but also in excess generates vertigo and fatigue. Because in addition, we are also mothers, fathers, daughters, sons, friends of people who need us outside. Well, you know, we can be also a bit of an everyday hero. Another break. The prophets of the catastrophes. Whenever changes are introduced in the university, at least in my experience, there is always a number of people who resist change. Often these resistance have to do with fatigue, fear of losing status, or personalities with low tolerance for change. Moreover, all this is usually not declared and leads to a defensive attitude. These people tend to feed off each other, generating an atmosphere that tries to pull inertia, making it difficult to move forward. The last one I am going to mention, obstacle, which is very important, the ones of the road. In life, sooner or late, we all get hurt. Sometimes we inflict pain on ourselves. Sometimes it is others. Sometimes it's the institution that damages through incoherence. The one generates pain inevitably. And then the temptation may be to step down, to disengage. But there are other alternatives. For example, we can also be more of a giraffe. And to finalize, with a positive note, we are going to a celebration. Here, the inspirational image is the Last Supper. I have chosen Leonardo da Vinci's wonderful painting, which is a meeting of friends. It is a way of saying that in this purpose, it helps not to isolate ourselves, neither individually, neither much less in sides, to have a sense of team, to redirect our personal ambition towards those of the group. Then we will be much stronger because we will support each other. And so finishing, we have talked about the Ignatian approach in responding challenges. An important house of this approach have emerged. All these aspects have to do with Ignatian identity and its way of facing challenges, which, far from referring to people retired from the world, talks about people whose spirit drives them to live their lives in a certain way. We have spoken of help, of reason and heart, of team building, of evaluation. We have spoken of people who find meaning in their lives, who thus become more resilient, capable of living better with conflicts, insecurities, criticisms, inconsistencies, and with their wants. This is part of the horizon that describes the Ignatian view of university education at the essence of its responses to the new challenges it faces. Thank you so much for your attention.
Thank you, Marianne, for exploring together with us the multi-layered challenge of motivating and empowering our students in a highly complicated world, and the different roles that us as educators are being called to act upon in this context. You mentioned to inter-allier learning design, and I think that this is a great link to the next, which is actually the last presentation on the Socratic method in Philippine legal education. So let me call our last presenter for today, Maita-san Gonzaga, I hope that I pronounced it correctly, who is the Associate Dean for Academic Affairs of the Ateneo de Manila University School of Law. Her areas of interest include human rights, political law, civil law, and legal ethics. Prior to joining Ateneo Law full-time, Maita served as a commissioner of the Philippine Presidential Commission on Good Government from 2010 to 2015. She has been teaching at Ateneo Law since her admission to the Philippine Bar in 2003, and she currently teaches law review classes in Ateneo de Zamboanga University and lectures for the LLM Diploma in International Law Studies program of Deusto University. And she also sits as a member of the Committee on International Law and International Affairs of the Integrated Bar of the Philippines. Maita, welcome.
Thank you very much. I will skip having a PowerPoint presentation and will endeavor to keep it to 10 minutes. So good morning and thank you again for the very warm welcome to Lisbon. My short presentation is really composed of the nascent thoughts for what I hope to develop further as a paper on legal education in the Philippines. Recent years have seen quite distinctive changes to the landscape of how we teach and how lawyers qualify for the practice in our jurisdiction. The bar exams used to be quite traditional and pageant-like in how it was approached. The bar exams which one needs to hurdle in order to obtain a license to practice in the Philippines was held only once a year for 4 consecutive Sundays. You take the bar, the exams the entire day by thousands of aspirants, approximately 8,000 the last time pre-pandemic, and centralized in one location in the capital, in one school in the capital. The Philippines is archipelagic with more than 7,000 islands. And so you can imagine what kind of production it would take for thousands of students to troop to Manila and stay for a month with all the pertinent effort and costs involved. It also used to be a series of exams where answers had to be handwritten. So you take the exam for 8 hours every Sunday for 4 Sundays, made up of essay questions, which sometimes required lengthy disquisitions. And so pity the poor examinee and pity the poor examiner who had to read thousands of answer sheets with varying handwriting. The last exams held earlier this year were finally digitized and were held in various provincial testing centers. This was a much needed development spearheaded by the Supreme Court, really. But there are some traditions and customs which may be slower or more resistant to change. And one of these is arguably the reliance on the Socratic method in Philippine law schools, or the touted reliance on the method in any case for the basic law course. Before I make the 3 points, which I will confine myself to in consideration of the time constraints, let me just quickly mention that to help me begin my own personal examen regarding this topic, I sent out an email to about 130 friends and colleagues who I knew to be teaching law and asked them to answer a few questions informally. Nothing scientific and nothing too complicated yet. That will come later. The questions I asked included, whether the individual employed the Socratic method in class, and if yes, a brief description of what he or she understood to be the Socratic method, how it was employed, what percentage part of the class for a term or a semester would be conducted using this method. And I hoped, but didn't quite expect, a lot of my friends and colleagues to get back to me on the email that I belatedly realized looked like spam mail. But I heard back from approximately 110 people. If we were to divide them, I had about 70 male colleagues answer and about 40 female colleagues answer. So I heard back from approximately 110 people, representing or teaching at approximately 38 to 40 law schools, or about a third of law schools in the Philippines. I'm indeed grateful for the generosity of spirit. So I also surveyed what had already been written or observed regarding the method in academic papers and presentations, as well as in social media posts. And there were quite a bit regarding the Socratic method, and usually not in very nice terms. In any case, from that, I drew my 3 points, which I will present as exaggerations and on which I will expound. So the first of the exaggerations is that the Socratic method is the root of all evil, or at least all that's wrong with Philippine legal education. This perception or abhorrence shown by many a student might stem from a number of factors, including a misconstruction of what the Socratic method is. As one Professor Torrey put it, in reviewing the literature about this, one thing became immediately clear. Not only is there no agreement on the value of this pedagogical tool, but there is also no agreement on exactly what it is. While most of those I asked had a fine understanding of the method, with one of my favorite answers being that it is a process by which a teacher draws from the student his views on the subject matter of the day, his reasons on why the law and jurisprudence currently stands as they do, and whether they should apply to hypothetical situations proffered, I did note that even from the answers of colleagues, there was a tendency to conflate the concept of the Socratic method with other somewhat similar exercises, such as simple recitation where a student is simply asked to regurgitate, preferably verbatim, legal provisions, or the simple case method where a student is again simply asked to narrate the facts, the issues, the rulings of the court without any need for critical thinking or analysis. These are obviously just tests of recollection. And because of the limitations of human memory, coupled with the volume of assigned cases for the day, often result in anxiety as one strives to remember as many distinct matters as possible. Now, the other factor that I tend to blame for the negative perception of the method is how it may have been misused or abused by teachers themselves. It has been called names: destructive, demeaning, dehumanizing. It has been accused of being the cause of trauma and humiliation. How the conduct of it caused one respondent, cited in an NYU academic paper on Philippine legal education, to be constantly in a state of panic, and another to describe the class atmosphere as hell. But a closer look at these reported personal experiences showed that the problem rested more with a particular professor and his conduct rather than the method itself. For instance, one paper talked about sexist language being common fare in the Socratic classroom, and how a respondent resented her decision to pursue law school because the Socratic method demeaned her. So it seems as if the blame is being put on the method, but honestly, a professor with such a fundamental behavioral problem is the issue and can make his students feel small and dehumanized in ways that have nothing to do with the Socratic method. So wielded properly, I am still of the position that the method has benefits that make it worthwhile. Now, the second exaggeration is that the Socratic method's star is now on a rapid decline. I've heard this one quite a few times in the recent past, that younger and more progressive faculties do not favor this remnant from the past and have adopted more student-friendly and less anxiety-inducing methods. Perhaps this claim may be true and may be verified in the future, but of those I asked, a lot of whom could be considered young and progressive, 16% said that they used the Socratic method 75% of the time during any given term. 30% conducted class using it 80 to 85% of the time. 19% used it 90 to 95% of the time. And 9% used it to the exclusion of all else. In other words, in the Philippines, from the respondents, about 75% used this method for at least 75% of the term. Here's the thing. Currently in the Philippines, unlike perhaps in other jurisdictions, approximately 97 to 98% of the law faculties are made up of professors of practice, all teaching part-time. Most of the over 100 law schools would have faculties made up of incumbent trial court judges, practicing litigators, government lawyers, and these folks would have full-time jobs outside the academe. And law school students are overwhelmingly those who wish to become trial court judges, practicing litigators, government lawyers. So law school is really a place to learn things which will allow one to hurdle the bar exams so one can practice for a living. There have been a lot of positive developments in recent years to modernize and rationalize legal education, but the law school curriculum is still, begrudgingly for the most part, bar exam driven. There is a lot of substantive matter to cover. For the bar exams, will test you on very specific subject areas. And most professors would have lengthy course syllabi with a lot of laws to cover as well as a lot of case lists to wade through. If one wishes to cover material quickly, really, the fastest way would just be to conduct lectures day in and day out. But if you have other course objectives and you wish to be able to hear and interact and engage your students without having to prepare creative activities which may require a lot of preparation and is time consuming, eating up time which you do not have, conducting recitation and employing the Socratic method to see how your students think and develop still seems to be a viable option. The final exaggeration is conversely that the Socratic method is the best there is, bar none, that this is the only way to go. And this does not seem to be right either. There are certain subjects and courses, of course, which would be better served by being taught through other methods like seminars, facilitated class discussions, moot court simulations, clinical exercises, etc. There are so many innovations brought about by new online learning management systems, technology, instruments, which seem to be better able to cater to the abbreviated attention spans of the younger generations, videos, interactive tools, etc. It seems a pity not to take advantage of all these. And we've seen how technology has also allowed us to soldier on with legal studies during the pandemic. Although, of course, my one realization is that no matter the advantages of Zoom, nothing comes close to having your students present, engaged, vibrant in the same physical space. Moreover, utilizing the Socratic method is not the easiest thing to do if you wish to do it properly, because it can really be time-consuming and requires a lot of patience, especially if you are teaching first years. But I have to say, in terms of developing students to think critically, one is still hard-pressed to find anything that comes close. Asking them questions and then more questions springing from the answers they give, leading the conversation to that point where the student himself or herself reaches the eureka moment, seeing a student's face light up when he or she gets the point and is able to articulate precisely what he or she means, that is still priceless to me after 20 years of teaching law. So in any case, as I said, these are but embryonic half thoughts, which I hope will gain more lucidity in the future. But thank you very much for listening to my early meandering notions. Good morning.
Thank you very much, Maida. What I haven't told you earlier is that originally I come from Greece, so I'm gonna completely agree with you when it comes to the fact that understanding the Socratic method is the greatest challenge above all. And I have to admit that your presentation left me with a couple of questions like, shall we blame the Socratic method itself or its users? Are young educators like myself actually trained in using the Socratic method? Does the latter fit in a speedy educational environment? But I don't want to further abuse my role as a moderator. I have already had the chance to make some comments. I would like to open the floor and invite all of you to ask your questions to our presenters that did an excellent job. So are there any questions in the audience?
Judiciary and looking at the methods that you have been doing, you've been trying to compare notes, no, from the first presenter up to the last, no, including the Ignatian slant to it, no, and we said that is this a matter that we can enter into partnership with, no, with any of the institutions, because whatever you do in the field of legal education, in a sense, applies also even to adult learners, no, well, law students are adults, no. But we have more adults in the field of the judiciary, no? But we think that we can really learn from each other's experiences, no? So one very basic question is, what can any of you, for example, offer the Judicial Academy at this point by way of partnership, no? In terms of methods, no? If you do have your own experiences in the field of judicial education in your respective jurisdictions, what can we enter into by way of sharing of experiences in the field of judicial education? Thank you.
So a knowledge transfer question to all of you. Carlo, would you like to begin?
Well, actually, so that's one way. That's one way we assist the Philippine Judicial Academy. But maybe just maybe to help our colleagues here address the question, can you tell us if in your jurisdictions you have something similar to the Philippine Judicial Academy? So the Philippine Judicial Academy trains, adds to they train members of the judiciary, judges, so that they can understand new laws, new methodologies. If there are similar institutions in your country, maybe you can share that. Okay, so, but yes, I think there's a really natural connection between the academe and the judiciary in that sense. So we would like to hear from our colleagues from Spain and Ireland.
So thank you for your question. We're just talking with Richard. The first point is that we also have links in UCD with the judiciary. And our school is actually very, the judges are very involved. So and the second point is that when we will have the seminar in July in Dublin, the concrete way to do that would be maybe to invite members of the judiciary, and then to also build on our experience of the micro-credential, which is very much targeted to an audience with a professional audience, adult, learners. So we will see if it works, if it's a good success. And if it's because I know that I have students who are professionals, solicitors, barristers. We have Gardaí. Gardaí they are the police, the name for the police in Ireland. Okay. So we could imagine that we could do something like that if you are looking for a concrete answer. Thanks.
Yeah. Well, I'm from the economic world, so I was asking my colleague to answer, but if I could answer what the Ignatian perspective could give to this kind of training, it is very important, the creativity. It is very important, the engagement, to achieve the engagement of the students and the professors too. There are other things that I have mentioned before, the being very near to the real world and to teach them how to look at it. And I think that are the principal lines that there could be in any training for lawyers. I do not know if you wanted me that kind of answers. So I was asking Felipe to talk about the special law training.
Yeah, but I think, I mean, that's my understanding, that the elements put forward by Marian from this Ignatian approach can be applied to students of law, students of economics, of pedagogy, of a number of disciplines, because there are core elements that can inspire our approaches and our teaching methods, our teaching objectives, our teaching goals. So I think that they can be applied to different disciplines and different schools.
Thank you.
Is there any other question in the audience? Andre from the University of Malaga.
Thank you very much. That's a question for Mariluz and Richard, but maybe it can foster a debate among the rest of participants, because I found very interesting the survey that you made. And my question is if you found any results regarding the less quality of education. I mean, if students learn less with virtual teaching instead of the face-to-face.
Thank you. I don't think from our survey that we necessarily got that. We got the anecdotal experience of our colleagues. This might be a crude way of thinking about it, but in terms of the divide between the negatives and the positives, my sense was that if you already had a negative perception of online learning, you automatically thought the students were suffering as a result. Our experience, we did have a university-wide survey of the students during the course of the pandemic about their experiences to kind of test their views, and it was interesting because some got a lot from it, like flexibility, living at home. They liked the online provision. Some students wanted more from us because there was that perception that they weren't getting the full experience, that they wanted more learning, more provision. And some of us certainly did that. I certainly did that. I gave lectures online and then gave follow-up seminars with them to try and then we had the students who were like, no, this is too much. You're flooding us with information and now we're being asked to do too much. So yeah, it was very, very difficult to gauge whether there was a general drop off in performance, but I would say that when we were marking and moderating grades, we took into account the impact of the pandemic in terms of the grades awarded, which probably led to a bit of inflation. And now we're managing the kind of we're not post-pandemic, but we are post-lockdown. We're managing that sort of transition back to what expectations are. And there was recently a story published in Ireland generally about university grades and the number of first class results reaching, in some cases 30-40%, huge proportions of the student body. So there's a sort of, it's difficult to know whether student performance has gone down and we're overcompensating, whether it's roughly the same and we're grading more leniently now. So very long rambling response to say the jury's out, I think, at this stage. I think it's going to be a longer term survey needed to see whether the impacts and the other.
Yeah, the other aspect is that we actually survey the students, we survey the staff, but we never survey the staff about how they think that their students perform. And it's very, as we said, it's difficult to evaluate if there is a big discrepancy. It's because of the low level of engagement, or if it's because of the lack of knowledge that they have acquired. So I think it's quite difficult to assess that. So because some students were actually more, we mentioned that they were doing more research in depth because they had, time to read. So sometimes they have a much more active life when we are not in pandemic. They have sports activities, they do a lot of things. And because they were at home, they had more time to read. So maybe they were reading more and learning more. But the only evaluation we had is the take-home exam. And for my part, my grades were as good. They were not so bad. Yeah, so I don't know.
Thank you so much for those insightful responses. The floor is to Chief Justice Gismondo, who also has a question.
Thank you very much. Not a question, but some comments. First, I'd like to ask permission for Marian Elias, if I can quote your statements in your presentation when the opportunity calls for it. I'm asking if I can use or quote your portions of your presentations earlier on the Ignatian education when the opportunity comes. Will you authorize me? I know it's intellectual property, so I want prior permission. Of course, I have more than 2 witnesses to attest.
Permission granted, it's official.
Okay, thank you so much for that. Couple of things. Also, you might have noticed the presentation of Dean Maita, Associate Dean, and the presentation of Dean Bistan as far as the Philippine legal education is concerned. Precisely, I don't know if Associate Dean Maita was describing me as one of the professors because she was my student and a number of students at that Ateneo Law School. But in any event, precisely the Supreme Court decided to make mandatory clinical legal education so that our students will learn what is the essence of law in reality. The Socratic method, which is the traditional way of teaching in the law schools, provide the theoretical basis of understanding the law. Now, we made sure that it's not enough that you memorize the rules, as I usually require for my students, but there should be the reality of applying the law, and that is through clinical legal education courses. And the Supreme Court determined that this is the best method by which we can train our law graduates when they join the profession. that they don't know, they are not masters of the theoretical aspect of law, but the more important thing is to how to apply it through our CLEP programs. That is the approach that we have decided when we implemented this rule on mandatory clinical legal education program. Thank you.
Thank you. Maita, would you like to comment on this statement since it was basically focused on the Socratic method?
No, I mean, I completely agree. And yeah, I think it's very important to note that while I still am a believer in the method, of course, this is not to the exclusion of everything else. And Ateneo law is, I think, very, very aware that as we teach our students the theoretical and the substantive part of the law, it's also very important for us to make sure that they are more than clinically prepared to practice. And so even before the chief and the Supreme Court made mandatory the clinical legal education program, Ateneo has had it in place for more than 30 years. We're not as old as UP. UP has had it since the 1970s, perhaps late 80s for us, but it has been there for quite some time already as well. So yeah, I totally agree with the chief, and he is the perfect example of someone who wielded the Socratic method in the most positive manner.
Great, thank you so much. I hope that you're going to have the chance to continue this very interesting debate over lunch. Before closing this panel, I have two announcements on the side of the organizers. First, I regret to inform you that the Sunset Party had to get cancelled because of unexpected weather conditions. You know that Lisbon is famous for its sun, but today we expect rain, so we are not able to hold this party. And the second announcement is about tomorrow. And I would like to inform you that you may leave your luggage at the hotel. And then after the end of this event, you will have some time to go back to the hotel to pick up your stuff before going to the airport. So I would like to congratulate once again our speakers for the excellent presentations that they delivered. I'm sure that you have provided a lot of food for thought for tomorrow and for the upcoming stages of the collaboration in the context of the CALESA project. I would like to invite you all to the lunch that is going to be served outside. And of course, invite the speakers to stay where they are to take the photo. Thank you so much, everyone.
Thank you to our moderator and all the participants for an insightful first panel session. We now close the first day of our conference. All members of the project CALESA and the representatives of the partner institutions are now invited to the lunch break that is being served in the atrium just outside this room. We kindly ask the moderator and the panelists to remain on the stage to take the official photo. Thank you.